In this video, we're going to be discussing pre-existing injuries in workers' compensation cases. My name is Bilal Kass, I'm managing partner at Pacific Workers. We are California's fastest growing workers' compensation law firm, and over the last 9 years, we've helped recover over $200 million for injured workers across the state. So first, it's important to understand how pre-existing conditions impact your case. In workers' comp, we have something called AOE-COE, meaning does your injury arise out of the course and scope of your employment? And ultimately, if you have pre-existing conditions, the doctor evaluates whether or not those conditions are the actual cause of your injury, or if the mechanism of injury, as you described, happened, is the source of your injury. So for example, someone may have a pre-existing back problem and they need to know whether or not the pre-existing back problem was what it was before the injury and is still the same way, or whether or not, for example, the injury made it worse. And deciding that is the difference between what's called an exacerbation or an aggravation. An exacerbation means that you had a baseline level of symptoms or pain or condition, and it went back to that baseline following your injury. An aggravation is much different. An aggravation indicates that your condition was actually made permanently worse by your industrial injury. And ultimately, it's the doctor's decision to decide whether or not your injury was simply an exacerbation or an aggravation. The second way pre-existing conditions come into account in a workers' comp case is something called apportionment. Apportionment refers to the doctor's opinion regarding permanent disability and deciding to what extent some of your permanent disability is due to sources that aren't your industrial injury. So for example, if you had a pre-existing back problem and you got an injury and your injury was an aggravation, meaning that you were permanently made worse from the injury, the doctor would want to decide then whether or not any of your current symptoms and condition are attributable to the prior condition. And they may say that 5% or 25%, 30% or even 50% is responsible. Now, there was a case, Benson, and it basically says that the doctor has to explain why. The doctor just can't simply say, because you had a condition that predated your injury, some or all of your permanent disability is associated with that. The doctor has to explain what the condition was, what your permanent disability is, and how that pre-existing condition actually contributes to your current level of permanent disability. In workers' comp, permanent disability has a monetary value attached to it, and so apportionment can be a key issue in really deciding how much your case is worth, and oftentimes it can really make or break the value. It's probably one of the biggest things that we as lawyers fight over, and it's important to understand the issue and be able to hold the doctor accountable if they don't apply the principle properly. It's always important to remember that apportionment is what's considered an affirmative defense, meaning that it's not the injured worker's burden to overcome apportionment. It is the defendant's responsibility to prove it, which means once you've established that you've been injured at work and you have permanent disability, it's the insurance company's burden to prove those things. So it's nothing that you're responsible for proving on your own, and if in fact the defense does not prove those properly, the judge has the power to set aside apportionment and find that all of your permanent disability and causation are attributable to the industrial injury itself rather than pre-existing conditions. Obviously, pre-existing conditions can be extremely complicated. Whether or not they impact your injury can have a really big impact on the value of your case overall and your ability to seek medical care in the future. If you're going through a case right now and the issue of apportionment or pre-existing conditions have come up, which for most of us it is an issue, I think it's really important that you contact a lawyer and get assistance with it, or at least consult with a lawyer and get their opinion. Oftentimes, challenging apportionment means taking doctors' depositions and writing requests for supplemental reports and identifying these particular issues in court and trial if need be. So it's not something you should do on your own, and if you're going through it, again, you should leave it up to the professionals. If you found this information helpful and want to know more about workers' comp, make sure you subscribe to our channel and give this video a like.